to dying intestate and what happens to your assets. And I vaguely remember hearing that so much will go to the wife and then the kids will divvy up the rest of it, I guess. Yeah. I don't know. But could you weigh in on that?
And by the way, are you a single or married person, Gail?
I'm married.
Okay. So you've asked me about what happens when somebody passes away intestate. Intestate means that they died without a will. So, Gail, if you're like most married couples, you and your husband own everything jointly. That means if you passed away, everything would automatically belong to him. No headaches, no hassles, no probate, because you own things jointly. However, Gail, if you have a $100,000 CD that's not owned jointly, it's in your name only, and you don't have a will, in other words, you die intestate, Florida statutes is going to write a will for you. And because you're married, Gail, it could fall into one of two categories. One is that you and your husband, you have children, but they are all through your husband. And in that situation, Florida statutes say that entire $100,000 CD would go to your husband. The other category is that, Gail, you have children other than through your existing husband. And in that situation, Florida statutes say that your estate would be split 50-50, 50% going to your children, to your husband, and 50% to your children that were through somebody other than your husband. Gail, does that answer your question?
Oh. Yeah. Okay, so we have one child together and two from his children from a prior marriage. And if should he die, I would get 50%. And then the three children divvy up the other 50, or
that's
how
true.
Does that work?
Okay.
So the
actually,
three.
No, Gail, I'd have to go back and reread the statute. Maybe you can remember off your hand. Gail, I can't remember if the other 50% would go to just his two kids or to all three kids. I'd have to go reread the statute on intestate succession to be 100% positive.
Yeah. Well, that's how I remembered it, but I don't know because I was getting my hair done yesterday, and my hairdresser said, no, everything goes to you. And I said, that's not true if my name's not on it.
That's not
so
true
right now,
because that's not true because he's dying without a will, and because he's dying with assets in his name only, and because he's dying with children that are not through you.
Correct. I get it. She just had it wrong.
Well, she was making some assumptions.
Thank you.
Okay, Gail.
Thank you so much.
You're very welcome. Thank you for calling us. So, Chrissy, we often talk about people who die without a will, and first thing I tell them is, like, if you die without a will, Florida statutes, there's no big surprises there. Florida statutes is going to write a will for you, and it says if you're single, it's all going to your children. If your children are deceased, it's going to go to your grandkids. If you have no children or grandkids, it's going to your parents. If your parents are deceased, it's going to your brothers and sisters and nieces and nephews right on down the line. Things get a little bit tricky when you die intestate with assets in your name only and you've got a spouse. I don't want to overly confuse people.
Right, exactly.
Hopefully I've explained it appropriately.
No, you did great. And of course, if anybody out there listening has questions, of course you can call and ask further questions, but I think, Tom, you explained it very well. You can call 844-580-9326, and you can also call attorney Holly Napick off the air at 407-423-5561. And I want to add as well that we are often asked the question, if somebody doesn't have a will, they think that then it automatically goes to the state.
Mm-hmm. True.
And just to clarify for anyone listening out there, that is not accurate. If there's not a will, it doesn't mean that then it will automatically go to the state. What that means is it means that the appropriate family members will get or family members will receive spouse, children, other family members. However, it will be by Florida statute, which is what you were mentioning a minute ago about that it will write according to Florida statute, which may not be exactly what you would want. However, just to confirm that it doesn't mean, though, that it will go to the state and it won't get to your relatives.
I want to get back to the basics, and that is that everybody should have a will. Occasionally we'll run into somebody and will say, Tom, I don't own anything. I don't need a will. Well, remember that when we do a will for you, we do 3 other related documents. It's a package of documents. When we do a will for people, we do a living will declaration where you ask that you not be kept alive by machines. We do a health care surrogate. So if you're not able to, you're appointing somebody to decide what doctors, what hospitals, what medications. And we do a financial power of attorney. So if you're not able to, you're appointing somebody to pay your bills and manage your financial affairs for you. So all 4 documents, in our opinion, absolutely critical. Everybody should have them at a minimum. So if you're sitting out thinking, oh, okay, I just heard Tom talking, I guess I really don't need a will. No, we recommend across the board, 100%. In our opinion, everybody should have a will.
In addition, most people have a vehicle, at least one.
Right.
That is one more reason, in addition to what you were saying, Tom, about having a last will and testament. Why? A vehicle will not go through probate. However, having a last will and testament will make it much simpler for the loved ones when they go to the DMV to transfer the title for that vehicle. So having a last will and testament, it's again one more reason where if you have that document, you will make it simpler for your loved ones to transfer title to your vehicle or vehicles, because it's about cars, boats, motorhomes, motorcycles, any of those things, that it's simpler when you have a last will and testament done by an attorney. That makes it simpler for the loved ones to take care of business for you.
Excellent point, Chrissy. So just one more reason why we think everybody should have a will. And of course, the Olsen Law Group would be pleased to assist you with that. We do offer a free initial consultation to talk about your will and estate planning. We can do that in person, over the phone, whatever is most convenient for you, or Zoom if you like. It starts by calling the Olsen Law Group at 407-423-5561, or go through our website, olsenlawgroup.com. Speaking of will,